On this episode of Garris Horn Insights.
So everything I'm seeing out there, Ray, I think the industry is missing. The industry needs to take a step back and look at not the technical elements of what this rule says, but why this rule is being put in place in the first place, right? Technology-driven banking is the future.
Thank you for joining us for our next episode of Garris Horn Insights. Today we have law partner John Levonick to talk about Rule 1033. It just came out recently. And I think it was important to now talk to John about not just what the rule is, but what's the practical effect on Rule 1033. Now, John, let me first ask you, if you read this, you look at it, some people might be either confused or it's just not directly connecting as to what this even is. It sounds like it's a data movement law, a data protection law to some degree, but what are we talking about here insofar as what activity is actually being regulated?
Well, first and foremost, thanks for thinking that my thoughts and comments were valuable enough for your broadcast, Ray. So appreciate that. The 1033 rule, I think everyone's caught up in the minutiae of detail. Everything I'm reading really focuses on the elements of the rule and the obligations it forces upon a financial institution. And, I think the industry has lost sight of the forest through the trees. And I think we need to step back as attorneys and as an industry and try to look into the crystal ball to say, what is the CFPB trying to accomplish here? And I think to answer your question, Ray, Rule 1033 it's effectively regulatory rails that are forcing innovation in an industry that has lacked real innovation historically. So I think the CFPB is stepping back and saying, we want to force innovation in financial services. Here's a regulatory framework. And that's what 1033 is. It's a regulatory framework, a place to start the discussion that basically puts the industry on notice saying, listen, industry, we need to collectively innovate. And the only way to ensure collective innovation is for, obviously, the CFPB to nudge the industry into innovation, enhancing archaic and seasoned and outdated technology infrastructures, and ultimately working towards the goal of consumer data sovereignty. You'll see the term open banking thrown around a lot here. What the Bureau is really looking to do is empower consumers to have the authority to control their financial data and not be prostrate to third-party or third-party technology providers that provide mission-critical services for financial institutions, but saying if a consumer wants to avail themselves of financial service or a financial function or an ancillary service to their traditional banking needs or financial services needs, that the consumer can do so, and the consumer can direct the financial institution to push and move what is effectively the consumer's data.
Okay, so let me ask you this. So give me an example of the type of ancillary service from a bank, or is it full banking? So is this a consumer going to a virtual bank, or is this a subset of banking services that they have a choice to send somewhere else? What exactly? Give me an example, if you will, about the type of activity you think is being governed here.
I think an obvious, without naming names in our industry, I think an obvious example would be a third party, a fintech that collects consumer banking data. Consumer might have different deposit accounts, might have different asset accounts. And this fintech aggregates asset and income and banking information and provides dashboarding to a consumer. Hey, consumer, look at your financial health, look at your financial wherewithal. And this fintech has an API into the financial institution to get to access the consumer data, or maybe the fintech goes out and scrapes data off of the website using the consumer's credentials, like the consumer's banking credentials are passed on to the fintech, not very secure, and that fintech goes out and scrapes the data out of the financial institution, which is not the ideal way of doing it. That's why this rule talks a lot about APIs. And so I guess the fintech that aggregates this data, that provides this data to the consumer, is arguably subject to Gramm-Leach-Bliley, the obligation to protect the consumer's data against a regulatorily defined schema, right, or obligations, a set of obligations.
So in this real quick, in this relationship, then what we're saying is the consumer is consenting to this. In other words, this is something that using this example anyway, they want to engage on the service using a dashboard, point and click. Let's do it. I think it's a great tool. And in order to do that, or at least now that third party is now governed under Rule 1033 insofar as either how they handle it. But it's that kind of a relationship, right? Is that what I'm saying? Did I get that right?
It is. It is. And what the rule does is it tries to break down these historical financial moats that the financial institution or the mission critical service provider to the financial institution has built around protecting, preserving their interests, right? Retaining the consumer, exclusivity of a relationship with the consumer. And these financial institutions make a determination on whom they want to integrate with through an API. And a lot of times they might charge a third-party service provider a considerable amount of money so the consumer can use that service provider and access the beneficial services of that service provider. And instead of saying no, the financial institution can set an artificial price that's very high that dissuades the fintech company from wanting to or having the ability to engage and integrate with the financial institution. And that's what this rule starts to chip away at. It's chipping away at these financial moats, these pretextual basis for protecting their consumers, protecting their depositors, protecting their relationship with the consumer, and moving towards not only empowering the consumer to have better control over their data and who has access to it under what circumstances and how, but it also starts to give the Bureau the ability to establish authority over these third-party service providers that might have been existing in a gray area over the last several years.
It seems like a double-edged sword now, at least in some ways. That being said, it's first of all, I think, as a general rule, I think the banks have a real concern, if I understand this correctly, have real concern. One, it's always about moving of data, right? They're going to be held accountable even though the consumer requested, who knows, right? So part of it is just there's a lot of moving parts, and do you want that floating out there unnecessarily? I think that I can see where a bank might have that kind of motivation to be reticent to give the information for that reason. Additionally, it is a relationship business. So what I'm hearing possibly is by using a third party tool, you go to Capital One, you said, hey, you have a credit card at X%, you can get a credit card somewhere else, and the bank is probably thinking I'm losing that account. Yeah. So now what's happening then, ironically, is okay. So that the third party company is now a little more emboldened, mostly under the guise of consumer protection for choice. But they're more empowered that consumers can do this and data can flow more freely. On the other hand, now they're also regulated, it sounds like. Am I getting this right?
Absolutely right. The term is fostering competition, right? They want service providers to compete on the merits and the value of the service, not based upon predetermined integrations. For example, in our industry, we've seen a lot of M&A over the last 10 years. A lot of consolidation of technology providers into a single platform where you see a large financial technology company now owning various elements of the supply chain in a consumer financial product that is then licensed or under service agreement to a financial institution, right? But what this technology company brings to the financial institution is an ecosystem of participants that are predefined, that are potentially owned by the same financial technology company, and pricing is set in a very non-competitive way because this ecosystem is controlled by the single financial technology organization or corporation. What this rule does, in my opinion, in a very subtle manner, it starts to break away and chip away at these large technology islands that have been built by these handful of very large financial technology institutions. You know, there's been, a lot of these technology companies have been buying the supply chain participants and controlling prices. The Bureau says, well, let's open that up to competition. We don't want a single financial technology organization to own the whole supply chain, because there goes pricing controls, there goes competition, there goes consumer choice and consumer autonomy. So while this rule doesn't explicitly say that, in reading between the lines, we can see what the Bureau is trying to accomplish. They're creating truly an open banking system, break down these financial moats, create and foster competition among these technology providers, all while empowering a consumer to ultimately take control and responsibility of their consumer data.
Okay, so kind of in a way leveling the playing field, if you will, or an attempt to, by empowering consumers to be able to move their data the way they want to without restriction or less restriction, and at the same time making these third-party companies as accountable as well as how they maintain the information and what they should do with it. Let's walk through some of the high-level requirements. How do we operationalize this? What are our concerns as a practical matter? Which is, John, your expertise. So I'd love to hear what you have to say.
Well, from a technology perspective, the joke's always been every financial institution is effectively a software company in and of themselves. What this rule does is it forces financial institutions, either directly or indirectly through their managed service technology providers, to create the requisite infrastructure to build this interoperability. And the rule goes on to define how a financial institution should engage with a third party that a consumer has requested the financial institution to engage with. It dictates how the financial institution must act, and it empowers the financial institution to make decisions still in the best interest of the consumer, protecting the consumer in the event that the financial institution has worries about safety or soundness. But it's really taking the financial institution off the hook for managing downstream third and fourth generation technology providers, right? And having them responsible for, security, data security and cybersecurity controls, and saying, well, the consumer wants this relationship. The financial institution, this is how you need to engage. These are circumstances you can reject the consumer's request, the limited circumstances you reject the consumer's request. And this is how you need to maintain and most certainly what you can and can't do, such as you cannot charge a fee, pass through a fee that is related to the API or the transmission of data. So this rule extends the notion of cybersecurity data privacy to APIs, right? APIs are basically application interfaces where two disparate applications talk to each other securely. And it says, it needs to be encrypted and how it's secure. And that the financial institution is responsible for a reasonable assessment of the requested integrating tech, but not ultimately responsible for everything that's done. It's 560 some pages, right? So it gets into the depth of the technical requirements, obligations of infrastructure, in the event that the GLBA doesn't apply to the third party, that the Federal Trade Commission, could step in. It has elements, and everything I'm reading put out into the industry is really focusing on those elements. And what I was looking forward to speak with you today, which you've brought out, is that not what does 1033 do, but why is it doing it?
Well, let's get into that. So why are we doing this? And then really practically, how do we impact, and what's the impact? How do we coexist? Is it as bad as it seems? Again, your opinion, your thoughts.
The question was, what effectively does 1033 do, and what's the practical implications on financial institutions? So the practical implications on 1033 is that it now forces a financial institution to act more like a technology company, more like a software company. It forces the financial institution, either directly through their own proprietary software or through third-party services, to create technology interoperability in a way that the financial institution might not have historically been comfortable doing, or might not have had an economic or interest in doing. There's a lot of pushback in the industry. I think a lawsuit's been filed already, the same day that the rule dropped effectively, arguing that this is overreaching, that financial institutions, specifically banks, this harms them, this is going to harm consumers. And it has the traditional arguments that the additional costs of compliance are going to be overwhelming. I think, Ray, you can recall, and I can recall with TRID, with ATR-QM, these are the same arguments we heard, that this is too complex, that the industry doesn't have the ability to comply in the timeline given, that the additional costs on an already expensive infrastructure or technology management basis is overwhelming to these financial institutions. But I think the Bureau, it started with Director Cordray, the Bureau is never shy about imposing obligations on financial institutions that force the industry to get creative in providing and creating solutions to solve for the regulatory obligations. And we saw that with TRID. TRID effectively rewrote the general business flow of how mortgage was originated. 1033 is rewriting how financial institutions, through their technology platforms, have to communicate, how they have to operate, and how they have to do it in the consumer's best interests. And effectively, what is the consumer's best interest in this process?
Well, in that context, the consumer's best interest, is that more principles-based? In other words, it's not real prescriptive and defined, or is it more prescriptive, saying, and when we mean it, it means, best for the consumer means this? Is there anything in there that gives us some kind of direction there? And it usually doesn't, so I don't know.
The overarching best interest of the consumer is the security of their data and ensuring that the interoperability that's mandated by this rule is done in a secure and responsible manner. It's what the rule is not doing, in my opinion. It does not create an overwhelming obligation on the financial institution to attest to the cybersecurity and data privacy controls of the third party for which the consumer is requesting an API into for accessing those services. There's a reasonable standard that's put on the financial institution. If they have reason to believe that there's GLBA problems, there's going to be questions by the industry to what's sufficient due diligence between a financial institution when engaging with a third-party technology provider, a third-party fintech. To what extent do they have to, attest to the controls and the veracity of their controls? Is simple disclosure and contractual reps made sufficient to get the financial institution off the hook for this due diligence? This is where the lawyers come in, and this is where best practices are created. But the power of 1033 is it's specific to what's important, specific obligations to what's important, but it's vague to how to fulfill those obligations. And it empowers financial institutions, obviously through technology providers, to creatively solve for this. And they say, this has got to be how it has to work. We're not telling you how to get there, but this is how it has to work. And we'll see how the industry responds. The one thing I'm confident with in fintech, Ray, is that no good commercial opportunity is left unserved in financial services and fintech. Fintechs out there provide all types of offerings and opportunities. So I'm curious to see how creative these fintechs can get in solving for these problems.
And again, and no good deed goes unpunished. So to the extent that you have banks as well, I can see where there's some concerns as to if the focus might be on the quality of the data and protecting the data, and maybe even taking them off the hook to some degree. If we get third-party providers now managing the data and they're handing it off, still it's now a requirement that can either be tripped up or reinterpreted going forward. That what we thought was in the best interest of the consumer, what we thought was a reasonable set of controls for the data by that third party, turns out by somebody else, could be, an auditor at CFPB, comes back and says that wasn't good enough. I'm not knocking either party of the issues. It's just I respect every time we have new regulations to solve a problem, that creates tripwires. But I see where you're going with that. I mean, this might be something that was needed or could, either way, going to your point, whether we like it or not, it's here. And the real goal is to navigate this and see how it works best. Do you have an idea of the effective date on this?
There's an array of effective dates based on the type of institution and the particular services. Generally speaking, I think it's a 16-month window that large financial organizations have. I think it's 2026, not 2025. So it goes into 2026, which gives the industry ample opportunity to fulfill these obligations. And not only from a technology perspective, Ray, one of the challenges organizations are going to have is that these obligations impose contractual obligations on the financial institution to address contractually with their vendors. For example, a current best practice or current practice in the fintech industry when engaging with a financial institution is to request and seek legal authority to hold the consumer's data for not only the purpose for which the services are provided, but to potentially de-identify or anonymize that data and use it and aggregate it and use it for ancillary services. Providing projections on the industry, providing, this information to trending analytics and et cetera. That best practices now has been codified with this rule where they say that, institutions can only hold data for the particular purpose for which the service provided. So it is quietly buttoning up these little loose ends in the industry, such as that. But a large financial institution has a lot of contracts to go through. And a large institution might have to go and amend contracts that permit the financial technology provider to retain data under certain circumstances, to use consumer data under certain circumstances. So, the 16 months from a technology development, that's no big deal. 16 months from a large financial institution going through hundreds of third-party service provider agreements. This is not only technology. This applies to service providers that are tech-enabled. It's going to be a lot of contract review, a lot of contract amendment, and a lot of scrambling to ensure that the contract doesn't inherently permit what is now a prohibited activity because of 1033.
And I think this is maybe a way, correct me if I'm wrong, I should say, maybe it's more than a creep, but it's a creep into controlling data and privacy. Not that being, if you recall, a few years ago in California, we had a Privacy Act that really started making us think differently about data. Where, remember back in the day with Graham Leach Bliley, for decades, it was a matter of we hold the data, we secure it, and that was the obligation. Now the inquiry is you're supposed to hold it, it should be secure, and do you still need it? And and to what degree do you need the data? And if you don't, maybe you should reconsider, not having it. And so it starts the cycle of thinking about what data do I have? Do I want the responsibility? Do I delete it? Do I need it or not? And what do we mean by need? It creates its own data. I guess it's data anxiety is always an issue. And it looks like, well, maybe, I don't know whether intentional or not, but this rule also has an effect on that because you have to rethink about what you have in your data, what you're retaining and what data you're retaining and why. Do you need it, not need it? Are you supposed to get rid of it or not? Are you supposed to share it then with a third party or not? It seems like, again, there's a creep insofar as, and I've been saying this for years, that we're going to rethink about data as a whole, not about we have and protect it. And then the new element is, but do we need it? And is there liability if I keep it? So that seems also to be some kind of an impact here, I think.
Well, a timely response to that, Ray, is we're coming up on an election, and this rule maybe is a response to Congress not being able to collectively get their stuff together and propagate a data security rule on a national basis, right? Maybe this rule says, well, we recognize the gridlock currently in Congress, and somebody has to act. We can't just stand by and let this emerging industry that's growing and go too long before we ask them to pivot. So maybe the Bureau said, now is the time to put down the regulatory rails, We're doing this because nobody else is, and it needs to be done. And let the arguments be had on to whether or not this is within their charter, within their purview. If another agency wants to step up and say this is our world and we're going to address it, I think the Bureau's accomplished what they're trying to accomplish. This has to be addressed. Consumers have to be protected, and somebody has to do something about it sooner or later.
Very good. Well, very good, John. Thanks for your time. Any closing ideas, thoughts on this before we kind of close out together here?
Yeah, we spend a lot of time focusing on the mortgage industry, Ray. You and I, and part of what we do on a daily basis. Because technology has always been behind the times, we exist in an industry that's still struggling to deal with cybersecurity and data privacy issues at the organizational level. This rule is going to force these organizations to get their infrastructure, controls, policies, programs, vendor management, oversight into order very quick. Because at the end of the day, the one thing that this rule clearly does is it opens up various avenues of regulatory oversight by the Bureau, where the Bureau can now hold institutions accountable where they arguably couldn't have previous to this. So I'm looking forward to seeing an industry grow rapidly and obtain the requisite knowledge and respect for cybersecurity and data privacy at the end of the day. And I think that this 1033 rule is the appropriate catalyst to do that. So I'm hopeful for our industry.
Okay. Well, very good, John. Again, thanks for your time, your insight. I greatly appreciate it. I'm sure the listeners greatly appreciate it, our audience here. So thank you for that. And with that, we close out yet another episode of Garris Horn Insight, and pretty timely on the 1033. So thank you for that. And again, everybody, look for the next episode of Garris Horn Insight, and we'll take it from there. Thank you, John. Thank you, everybody.